Day 2, the Kingdom of Spain against Infrastructure Service Luxembourg and BV, and the Republic of Zimbabwe against Border Timbers Limited and the Development and Co.
Mr. Harris, good morning. Before you embark on the scheme that you've outlined yesterday, can I raise one matter with you for clarification? It is said that it is common ground between the parties that a waiver of immunity must be express. Now, two questions. Do you accept that? And what do you mean by that? If so, what do you mean by that?
You seem very eager to jump up.
My Lord, may I mention, if it's helpful, the parties are, at least at the stage of generality, agreed it has to be express. And you can contrast that with what we find in section 2.2 of the SIA, the very section that we are concerned with, where it says, for the avoidance of doubt, choice of English law won't amount to submission. So that's a compelling example of what might be implied. So the real battleground is not the sense of it being expressed as contended by them, but a sense of it being expressed as in the sense it needs to be clear.
Well, the difficulty I have is that you qualified by saying, as a matter of generality, we accept the proposition, well, but I don't know what that means.
Well, we don't accept it has to be expressed in the sense that they say. And there's
they seem to accept it yesterday that inevitable consequence will do, which to my mind is necessary implication.
Yes.
At least that's how I understood their submission. So.
Yes. My Lords, I don't want to take up my friend's time. All I would say is that we made clear in our written case that although it may not be very helpful where there's a dispute about what express means to say the parties agreed it has to be express, because express doesn't find is not included in the section. So I'll perhaps.
I will be dealing with this very point in the course of my submissions in the next few minutes. The short answer to my Lord's question is we accept that it is express in the meaning that we have given to express, i.e. which includes something which necessarily follows from the words used, but doesn't require explicit language in terms of the words waiver, immunity, and things like that. And that, as my learned friend Mr. Green said, is the issue. So what we would say in terms of the international law position as to what express means, because as my lords know, international law doesn't have this concept of express and implied obligations and terms in the same way. What we would say is express means clear, and clear is what you get to by the interpretative process of Article 31, and possibly, if you need it, Article 32, which is where I'm going to start my submissions this morning.
So express means clear?
It does mean, yes.
And you accept that waiver must be expressed in the sense that it's possible to extract a waiver from the express terms of the contract, but you draw the line at the implication. But you draw the line at saying that the word waiver must be used.
Yes, so we say that you don't need to have the word waiver or the word immunity if the effect of the language used is that what it means is that there must be a waiver, that what my Lord Legate put as necessary implication, we prefer to speak of it as a consequence that follows from the language used to avoid, because although we didn't hear about it yesterday, there's a lot in Spain's written case about English contract law principles which in our submission are plainly inapplicable in this context and of no assistance to the court. That's why we sort of, I think, we're all slightly hesitant about necessary implication as opposed to flows from the language. But I will come on and show you both NML and general dynamics in the Court of Appeal where this point has been addressed.
And you wouldn't, is this all part of your submission, you wouldn't expect to find an international convention language which slavishly followed one particular state's own law about state immunity. So you're really looking for conduct described by the convention which, applying our own state immunity glasses amounts to a waiver or a submission.
Correct.
Yeah.
Correct. I think that nowadays there are more than 160 states parties to the ICSID Convention,
yeah,
with radically different traditions. So, with that preliminary observation, turning then to my first part, the proper approach to determining whether Section 2 of the State Immunity Act is satisfied, it's convenient to start with the Section 2 framework. That is at Authorities Bundle, Main Authorities Bundle, at tab 9, page 62. It says, as my lords and my lady know, a state is not immune as respects proceedings in respect of which it has submitted to the jurisdiction of the United Kingdom. And sub 2, a state may submit after the dispute giving rise to the proceedings has arisen or by a prior written agreement, and that, by section 17, extends to treaties. There's no dispute about that. The correct approach in my submission to identifying whether a state has given its consent is by way of a two-step process. First, the court interprets the instrument in which the consent is said to be found according to the law applicable to that instrument. So for a treaty, as is the case here, that is the customary rules of treaty interpretation. So first step is treaty interpretation. Secondly, once the meaning of the relevant treaty provision has been identified according to its applicable law, one then asks whether it meets the English law requirements of Section 2. That's the second step. And that is a matter of statutory interpretation. So in that respect and to that extent, we agree with Zimbabwe's general approach that the proper interpretation of the ICSID Convention provides what they call the input for the Section 2 analysis. And that two-step framework, as I will now show you, is also reflected in cases such as General Dynamics and NML. As to the second step, so the Section 2 analysis, even though it comes second, it is convenient to address it briefly now, as there is only one condition that is relevant for this appeal, which is that Section 2 requires the submission to be express in the sense we've been discussing. Now, incidentally, my learned friend Mr. Moulin said yesterday that the requirement under Section 2 for the submission to be express reflects and is consistent with the requirement for the waiver to be express under custom. And we accept that. It does, of course, depend on what express means in the sense that we've explained a moment ago. We say it just means clear and the outcome of the interpretative process is clear. But we accept that there is a connection between the two. So, English authority, in the form of the unanimous Supreme Court decision in NML and the Court of Appeal's judgment this year in General Dynamics, confirm that for the purpose of the State Immunity Act, express does not mean explicit, no requirement for any specific form of language or anything like waive or immunity or jurisdiction. And let me take you to those cases briefly, since Spain seems to assert still that you need specific words and something more than an agreement to exercise jurisdiction. It's convenient to start with the Court of Appeal in General Dynamics earlier this year. That is at Supplemental Bundle 1 at page 20 it starts. So the first Supplemental Authorities Bundle at page 20.
And the amendment, please.
I didn't think that the states did say that they had to be express words. And they talked about necessary implication and inevitable consequence. But have I misunderstood that?
Yes, our understanding from reviewing the transcript yesterday, and I will get you the reference, was that it was still being maintained by Spain.
Oh, Spain.
Not Zimbabwe, but by Spain, that there is a need for language.
I can stop my friend, that's not Spain's position that there are words that are required, of course not.
Well, that's helpful. Yes. I mean, perhaps the clearer point is the submission was certainly being made yesterday that you need something more than the natural meaning of those words necessarily means that the immunity is waived. It needs something more than that. And that is perhaps what I'm pushing back on more accurately. So, General Dynamics, Supplemental Authorities Bundle, page 20. This was a case about whether a clause in a Swiss law contract that provided that an ICC arbitral award would be, quotes, wholly enforceable, waived immunity both from adjudication and from execution. If my lords, my lady, would turn to page 21, at the bottom of page 21, the clause is set out, clause 32 of the contract, in the judgment of Lord Justice Phillips. And you see the relevant part of the clause at the top of page 22. Both parties agree that the decision of the arbitration panel shall be final, binding, and wholly enforceable. Now, the issue in that case arose on an application to set aside an interim charging order. So the case was chiefly concerned with whether there was a waiver of execution immunity under Section 13(3) of the 1978 Act. Although it concerned Section 13, the case is instructive because the Court of Appeal stated that the approach and confirmed that it also applied for Section 2. And it is also dealing with the similar issue of waiver required under Section 13. And my lords, my lady, if you turn on to page 25, at the top of page 25 you have the first ground of appeal, proper interpretation of Section 13(3) of the State Immunity Act. Libya's first ground of appeal is that the judge erred in holding that clear words are not required for a state to consent to execution against its property within the meaning of Section 13(3) of the State Immunity Act. So it was an argument about statutory interpretation, going to the second stage of our test. If we then move down through the reasoning of Lord Justice Phillips, with whom I will show you in a moment, Lord Justices Zaccaroli and Lewison agreed on this ground one point. The key paragraph is over the page on page 26, at paragraph 32 of the judgment. Perhaps, my lords, my lady, you would read paragraph 32 to yourselves. So what Lord Justice Phillips is doing in that paragraph is, firstly, he says the task of the court, so he starts off by saying that what is required, and there's no justification for any gloss, and then he says in the end of the third line, the task of the court is therefore to determine whether and to what extent the state gave, that is expressed, its consent by construing the words used according to the law applicable to that exercise in the present case, Swiss law. So that's the first step, looking for consent by construing the relevant text according to its applicable law, which in that case was Swiss law, in our case is customary rules of treaty interpretation. Then Lord Justice Phillips continued, once the court has determined that the state's consent for the giving of the relief in question was expressed by the written words, Section 13(3) is satisfied. As is common ground, there's no need to use the word consent or any other specific wording. It is unclear what would be required beyond that the words used express consent for that consent to be regarded as express. That's the second step, considering whether the requirements of the State Immunity Act are met as a matter of statutory construction. Now, as I said, Lord Justice Phillips here was interpreting Section 13, but he then goes on to say that the analysis is the same for Section 2 and makes reference to his judgment in the Court of Appeal in this case. as in the case that's before you on appeal. That we can pick up over the page at page 27, paragraph 34. And he refers to what he said below, with which the Chancellor and Lord Justice Newey agreed. And that passage in quotes, if the express words used amount on their proper construction to an unequivocal agreement by the state to submit to the jurisdiction, that is sufficient to satisfy section 2.2 of the SIA, even if the words submit and waiver are not used. Then 35, he says, the same analysis is applicable in relation to section 13.3. It follows that I see nothing in the purpose or context of the State Immunity Act, nor the European Convention, that requires section 13.3 to be read as imposing any obligation other than to construe the written words used to determine whether the state gave or expressed the consent in question. And just for your note, Lord Justice S.A.R.L agreed on issue 1, that's paragraph 48, and Lord Justice Lewison agreed, and that's paragraph 49 of the judgment.
Well, he seems to say the opposite of what you said at the beginning of this morning, that there's no need for an additional requirement of clear words.
The clear words, what I was meaning, or what I intended to say at least, was that you need to have the clear meaning of the words. It's not so much clear words, but the clear meaning that you get to.
I don't understand the difference, I'm sorry.
I have to say, I find the last sentence of the quoted passage in 32 quite difficult to understand. I mean, if it's
I think he's saying, isn't it, it's simply a matter of interpreting the words used.
Yes.
If those words as interpreted mean X, then it's X. So there's no super added requirement for them to be clear and unequivocal or anything like that. It's just an ordinary question of construction according to the applicable law.
Absolutely, my Lord. And apologies if I wasn't clear on that earlier.
Well, sorry, just on that, I think he is saying that they have to, I agree with all of that, except that the words do have to be clear and unequivocal in order to convey the consent. I mean, I think that is the sense of the last sentence of paragraph 32.
Yes, if it was ambiguous.
That wouldn't be good enough.
That wouldn't be good enough.
No.
The trouble is we're constantly in this court construing statutes and private documents which at first sight, and possibly in the eyes of the courts below, don't look clear, and deciding what they mean. And at that point, that's the answer, even if getting there was like going through a forest.
Well, yes. And that, as I explained earlier, is the same approach that is under Article 31 and 32 of the Vienna Convention on the Law of Treaties. As I'll show you shortly, you go through the process and what you come out with is the clear meaning of the words. My Lords, it may just be worth pointing out that Lord Justice Lewison goes on to say at paragraph 57 on page 31, I think what he says rather concurs with what my Lord Legate and Lord Briggs have put to me a moment ago. At paragraph 57, he says, the requirement of section 13.3 that the state in question has given written consent, I accept that the consent must be express consent, but if properly interpreted in accordance with its governing law, a written contract does give consent, then in my judgment, the subsection is satisfied. So he keeps it quite short on that. Libya sought to appeal that interpretation of section 13 to this court, but this court, including two members of this panel, refused permission to appeal on the basis that there was no point of law that was arguable or of general public importance. So general dynamic demonstrates two things.
We're not sure you're allowed to rely on it.
General dynamics demonstrates two things. Firstly, it confirms the two-step approach to determining whether a waiver exists under the State Immunity Act. And secondly, it demonstrates that if the instrument on its proper interpretation, according to its governing law, expresses consent, to the courts exercising jurisdiction, then that is an express submission for the purposes of the State Immunity Act, with no heightened requirement in relation to specific or explicit language. Second case I wanted to show you is the decision of this court in NML. That case is at page 563 of the main authorities bundle. Main authorities bundle 563. It adopts an approach which is consistent with that in general dynamics, but specifically concerning Section 2 of the State Immunity Act. If my lords, my lady, would turn on to page 586 of the authorities bundle, the relevant clause, there were two clauses. The relevant clause that we are focused on is the first. They are treated separately by the justices. The first clause is in paragraph 57, it's set out. The related judgment shall be conclusive and binding upon Argentina and may be enforced in any specified court or in any other courts to the jurisdiction of which the Republic is or may be subject by suit upon such judgment. So Argentina was accepting that the judgment could be enforced against it in any court which would have jurisdiction, despite my learned friend Mr. Bastin's pains to try to distinguish it. The court will see that this clause is similar to what we have in Article 54 of the ICSID Convention in our case. And it was our case below, as it is here, that the waiver in Article 54 is just as clear as the one in NML. There is no specific language in this clause of submission, waiver or immunity, or jurisdiction, for example. Now, on this point, the court was unanimous. Paragraph 58 records that the judge at first instance, Mr. Justice Blair, and sets out that he considered that this provision constituted a submission to the jurisdiction of the English court, inasmuch as Argentina unambiguously agreed that a final judgment on the bonds in New York should be enforceable against Argentina in other courts in which it might be amenable to a suit on the judgment. And at 59, Lord Phillips notes that Lord Justice Aikins on appeal did not agree. He thought it was neither a waiver of jurisdiction nor a submission to the jurisdiction of the English courts. Sorry, neither a waiver of immunity nor...
Well, he says waiver of jurisdiction.
Yes. Apologies. Nor a submission to the jurisdiction of the English court. And Lord Phillips then says, I do not follow this reasoning. It seems to rob the provision of all effect. Now, my learned friend Mr. Moulin, in his written case and yesterday before you in oral submissions, suggested that what Lord Phillips was saying was that it was necessary, in order to find a waiver of immunity in the clause, it would have to be necessary to find that waiver of immunity to give the clause any effect. So that if the clause was operating in some other way, then you wouldn't find that waiver. But that is clearly not what Lord Phillips is saying here. He was reacting to what Lord Justice Aikins had said, that it was neither a waiver nor a submission, and saying that if that was right, it did neither of the two jobs that Mr. Justice Blair had identified, and then it would be robbed of all effect and serve no purpose. So in my submission, that doesn't support my learned friend's proposition that you can only have a waiver where the clause would otherwise have no role or effect. The clause that we're looking at was held to be a waiver because it was the clear meaning of the words used, not because it was necessary to imply a waiver to save the clause from being otiose. Lord Mance, at paragraph 83 of this judgment, which is on page 599, agreed with Lord Phillips on this issue. To be clear for your note, it is the third issue. So Lord Mance says in the third line of his speech, I agree with Lord Phillips' judgment on the second and third issues. And so did Lord Clark at paragraph 138, which is on page 611 for your note. Lord Collins, who is the other justice who addressed this issue separately.
Sorry,
Oh, apologies. Lord Clark is page 611,
yeah,
paragraph 138.
thank you.
I agree the appeal should be allowed for the reasons given by Lord Phillips of Worth-Matravers, PSC. And then he gives a short separate judgment on another point where there was a disagreement, but not the third point. Lord Collins was the other justice who addressed the third issue separately. He came to the same conclusion, and we can turn that up if we go back to page 600 and, sorry, go to page 610, just the previous page, at paragraph 128. See, he's talking there, just in 127, you see he quotes that clause, just that first clause. And then in 128, says the New York judgment was on any view a related judgment, and Argentina agreed it could be enforced in any other courts to the jurisdiction of which the Republic is or may be subject. This was the clearest possible waiver of immunity, because Argentina was or might be subject to the jurisdiction of the English court, since the English court had a discretion to exercise jurisdiction in an action on a New York judgment by virtue of the CPR. That clause doesn't use any specific language referring to a submission or a waiver, but the Supreme Court held quite clearly that the clause was a submission to the jurisdiction of the English court under Section 2. Now, the way in which my learned friend Mr. Bastin addressed NML yesterday in oral submissions might have given the impression that the judges approached the interpretation of the bonds by taking the first and second clauses together. That is, in my submission, wrong. There was a second clause, as Mr. Bastin showed you, that was also held to constitute a separate waiver of both adjudicative and execution immunity, but that did not affect the construction of the first clause. Lord Phillips construed the clauses separately and held that the second clause was an independent submission and considered the two clauses as jointly and severally constituting submissions to the jurisdiction of the English courts. That's at paragraph 61 of the judgment on page 587, my lords. And my lady. And he then said at paragraph 62 that the conclusion did not involve a departure from the narrow approach to construction required by the law of New York. It gives the provisions as to immunity in the bonds the only meaning that they can sensibly bear.
So were they applying New York law in this case?
Indeed, yes. It was a New York law government agreement. Apologies.
Which did allow implied waiver.
That's not something that they address.
No.
Well, it's not. Is this case just an authority on the effect of New York law then?
No, my lord. In my submission, it isn't. It is an authority as to what. This is an authority on Section 2 and how you approach Section 2.
Right.
And New York law on this, as one can see in this paragraph, the reality is, in paragraph 62, the reality is Argentina agreed that the bonds should bear words that provided for the widest possible submission to jurisdiction for the purpose of enforcement, short of conferring jurisdiction on any country whose domestic laws would not, absent any question of immunity, permit an action to enforce a New York judgment. It is also Lord Collins. I was going to give you notes at 610. You probably saw it, the paragraph below where he says the waiver in the first clause is confirmed by the waiver in the second clause.
Where do we see that?
That's at page 610, my Lord. Apologies, it was the immediately following passage. So paragraph 129 on page 610. He deals first with the first clause and then he says it's confirmed by the second. And just to make good the point, the question of what amounts to a waiver in New York law doesn't actually matter for these purposes, because the question of what is a waiver is for the purposes of Section 2.
Yeah, it's your second stage.
Yeah. It is.
Well, New York law is relevant to understand what, by the New York law document, they have actually agreed to do. But then it's an English law question whether that amounts to a submission.
That's correct, yes. And just for your notes, the Court of Appeal in General Dynamics makes that same point at paragraph 46 of that judgment, because it's being submitted in that case by Libya, the General Dynamics case, that Swiss law has certain different approaches to waiver of immunity. And Judge Pelling at first instance and the Court of Appeal both held that that was completely irrelevant to the analysis that was being undertaken here. So, that's the first part on Section 2, and that's what I wanted to say for now on Section 2. Moving to the second part then, which is the first stage of our two-stage approach, the interpretation of Article 54 of the Convention. The cardinal rule of treaty interpretation, as the Court knows, is reflected in Article 31.1 of the Vienna Convention, to which you haven't really been taken yet, perhaps because it's so obvious. Let's turn it up. That is at page 2907 of the main authorities bundle.
Yeah, for some reason we looked at it in the supplementary bundle yesterday, but
it's complete there.
Oh.
But anyway, you say 290.
The version is in there. That's what
Well, the relevant part that I need is at 2907. If you prefer to look at it, I'm sure it's the same.
Yeah, I'm sure it is too.
I just don't have the reference to hand. Hasn't changed in the printing. So, Article 31.1, a treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty, in their context, and in the light of its object and purpose. It is, importantly, a single combined exercise. The text and the context and the object and purpose of the treaty have to be taken all together before the meaning of the provision is arrived at. That was noted by this court in the JTI Polska decision. It's probably not necessary to turn that up, but for your note, it is at paragraphs 26 and 27 of that judgment, which is at authorities bundle pages 470 to 471. And we've also given an authority from the International Court of Justice on the same point in our written case at paragraph 32, which is at Zimbabwe.
Which case is that?
Somalia and Kenya, my lord. That is core volume, page 121, for your note. 121, Lord. The outcome of that exercise... My lord was asking for the reference to our written case, or the reference to the Somalia case.
I understand that, yes.
My learned junior was just asking which was the reference you were looking for. The outcome of the Article 31.1 exercise is that the objective meaning of the treaty term, which is then taken to be the authentic expression of the intention of the parties, and which then cannot be contradicted or overridden by supplementary materials such as the travaux. And that reference to authentic expression of the intention of the parties I take from Mr. Justice Bryan's judgment in GPF in Poland, which is at page 395 of the authorities bundle. Now, this exercise is not an exercise that was attempted yesterday by either of the states. Spain skipped from text to travaux, missing the mandatory elements of context and object and purpose of the treaty. Mr. Bastin was attempting to confirm through travaux his version of the outcome of interpretation under Article 31 without having completed the application of the rule in Article 31.1. And Zimbabwe argued almost entirely by reference for a test for necessary implication, which my learned friend derived from Pinochet and Lama, rather than starting with the application of the rule in Article 31.1. I am going to go through the stages of the rule in Article 31.1. Turning then to the first part of that holistic interpretative exercise, the text of Article 54.1, and we should turn that up. It's at page 2845.
Just before we leave 31.1, object and purpose, is there any relevant distinction between the two? Or is it just using two synonyms because it sounds stronger?
That, I think it is.
Lawyers like to do that a lot, like null and void. And
yes,
it sounds more like two synonyms. Okay. Yes.
Yes. I just, wondered because I'm not sure I can see anything.
Yes. I suppose there may be an unusual case where there is a difference, but I can't think of one offhand.
Not here, anyway.
No. My Lord, so 2845 is Article 54. It's the main authorities bundle, 2845. Each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state. Just the first sentence there. So Article 54 there imposes two obligations on contracting states. Firstly, they each shall recognise ICSID awards as binding. And secondly, they each shall enforce the pecuniary obligations contained in an ICSID award within their territory as if they were final judgments of their own courts.
What does that mean, actually, enforce the award? When you talk about enforcing a judgment or award, you normally mean executing it.
Well,
obviously you don't here because the execution has a separate meaning. So what does it actually mean to enforce it beyond treating it as if it were a final judgment? Probably nothing. Just as a way of saying, is it that it's to be treated in the same way as you would treat a final judgment of your own court?
Yes, it's
given the same status, or
you've gone through the process of the simplified process of registration, which has the effect of transforming the award into something which has the status of a judgment of the court in the relevant state. Yes. Obviously, we're looking at it through English eyes, but this happens in all the different countries.
Right, but I would have thought most jurisdictions, if not every, must recognise the difference between treating something as binding and executing it, executing a judgment.
Yes, but there is clearly a distinction that one sees in the text of the Convention, and I will be coming on to this with Article 54.3 and 55. Execution is something that is slightly different. So the enforcement piece is the first bit of having the award transferred, translated, transmuted into the domestic legal context.
Maybe the second sentence provides a bit of a confirmation of that. Treat, within the federal system, treat the award as if it were a final judgment of the courts of the state. So you're treating it as if it were a final judgment if you've only got one jurisdiction of that jurisdiction, or if it's multiple, it could be as if it were a final judgment of any of the constituent jurisdictions.
Well, that's right. So, my Lord, the two obligations there that I identified, they are what Spain and Zimbabwe focus on. and say that it doesn't follow from those two obligations that states agree to waive their immunity. But that ignores the second aspect to Article 54.1, the opening words, each contracting state shall have those obligations. So when each contracting state becomes party to the ICSID Convention and consents to Article 54, it is not just assuming the obligations I have just mentioned to recognise and enforce awards, it is also consenting to the fact that all other contracting states are also subject to the same obligations to recognise and enforce ICSID awards. That's the network of mutual enforcement obligations to which this court referred in Mikula, which we already looked at yesterday. It's therefore clear in my submission as a matter of language that a contracting state consents by Article 54 not only that it will recognise and enforce awards, but also that awards to which it is a party will be recognised and enforced in other contracting states through their exercise of jurisdiction. That is simply the meaning of the words used in Article 54 without any need to get into necessary implication.
Well, it comes from your agreement to that, doesn't it? I mean, what is off the page, so to speak, is the fact you're agreeing to this treaty,
yes,
which is then you're agreeing that it shall be the case. You're giving your contracting states agreement to that being so in relation to other contracting states.
You are consenting to it, yes.
It's reciprocal.
It is.
Yeah.
Yeah, and I mean, and in fact, at the end of the preamble on page 2829, the whole treaty starts, have agreed as follows, which is my Lord's point. So you have to read it long,
Indeed.
Which I think is what I was putting yesterday. If you read it long, it means I, Spain, have agreed to you, UK, doing certain things.
Indeed, Lord. I was just turning to that very point, because Spain suggests in its written case at paragraph 24.2 that it isn't necessary, nor does it make sense, for one state to consent to another acquiring obligations under a treaty. It says that the UK can acquire obligations under the ICSID Convention without Spain's consent, for example. But that, in my submission, misunderstands how treaties work. When states sign up to treaties, they consent to all of the provisions of the treaty, subject to any permissible reservations that the treaty allows. And that is just as my Lord Sales just mentioned yesterday, just as is set out in the preamble to the ICSID Convention, which begins, the contracting states, ... have agreed as follows.
I think Article 17 of the Vienna Convention, I think it's Article 17, says something about a state becoming a party to a treaty, agreeing to the entirety of the treaty.
That's absolutely right, my Lord. It is a basic point that ought not to need too much authority, but in the interest of time, I can give you some references. It's the Articles 11 to 17 of the Vienna Convention on the Law of Treaties that address this point. They are to be found at pages 2903 to 2905 of the main authorities bundle. And my Lord is absolutely right that Article 17 says that without prejudice to Articles 19 to 23, which are the provisions on reservations, the consent of a state to be bound by part of a treaty is effective only if the treaty so permits or other contracting states so agree. So you can't agree generally to a part of a treaty. I will also give a reference in that regard, if needed, to the International Law Commission's final commentaries on the draft articles that became the Vienna Convention on the Law of Treaties at 3362 to 3363 of the authorities bundle, and also Jennings and Watts in Oppenheim's International Law 9th edition at page 3532 of the authorities bundle. Make good that point. Now, the third aspect of consent was, in my submission, conceded by my learned friend, Mr. Moulin, at transcript page 117, lines 9 to 12 yesterday, and is also self-evident in my submission. that the obligations that are being consented to in Article 54 are obligations of result. So it was accepted that the obligations are obligations of result. States are obliged to recognise and enforce awards, i.e. to achieve those results. And those obligations are inconsistent with the maintenance of immunity. So it is not sufficient in my submission for the states to create a mechanism which may, in some cases, assuming on the learned friend's case that you succeed in a de novo rehearing of jurisdiction with all the procedural consequences that that may entail.
But they're not just promising to enforce awards, though. This is important. They're treating them as if they're a final judgment of their own court. And once you've got a final judgment, questions of immunity, of adjudicative immunity have gone, and you've got the judgment.
Quite right, my lord. Quite right.
And still, no doubt, immunity you could have from execution of it, and that's what Article 55 tells you.
Indeed, my lord. And the point I was making is simply that the proposed Section 9 way through wouldn't result in the recognition and enforcement of an award necessarily in every case, which is the obligation of result that is before you. So, my lady, my lords, in my submission, it's clear from the text alone that Zimbabwe has consented to the UK exercising jurisdiction over it, because it consented to the UK being obliged to do just that under Article 54.
Okay. It may be common ground, but this is all dependent upon the award having been rendered pursuant to the Convention, which may or may not introduce a requirement as to the validity of the underlying arbitration agreement. One assumes it doesn't because of the restrictions in this convention upon a contracting state examining that question.
Absolutely, my lords.
That's a separate issue, though, isn't it?
It is.
Yes. But it's relevant to the... it's part of what one has to understand when interpreting Article 54, quite apart from whether it's a separate issue.
Well, what one sees is that, for example, in the 1966 Act, all that is required is the presentation of an authenticated copy of the award.
Yes. Mm. It essentially means authenticated.
Authenticated by ICSID, the Secretary-General of ICSID. The ICSID awards, the members of the court may have seen them, they come with a covering page, which is a certificate from the Secretary-General of ICSID certifying the authenticity of the award under the ICSID.
Well, that's Article 54 too, isn't it?
As well, my lord, yes.
And the argument is that that's the only requirement, as long as you've got the designation of the Secretary-General, that's it, and there's nothing else for the enforcing state to do except checks that is got the right stamp on, basically.
And that there's not been a stay, for example, by the ad hoc committee. That's the other aspect, to be completely clear. But it's certainly not that it goes beyond that. So that's Article 54 text. Now turning to the context in which Article 54.1 appears.
And you can contrast, like the New York Convention, where you do have certain reserved arguments of public policy, which you don't here.
Public policy, proper constitution of the tribunal, jurisdiction, there are lots of different options under the New York Convention, which is radically different, and that is indeed one of the key features of the ICSID Convention that distinguishes it in this area, and why parties choose it. So, context I can take fairly briefly, because neither Zimbabwe nor Spain have much to say about the contextual factors that we say provide considerable support for our interpretation of Article 54.1 as containing a waiver. And neither do they really raise contextual factors which they say support their own cases. I have 3 points on context. The first point is the scheme created by Articles 53 to 55 of the Convention is plainly intended to be a self-contained system that prevents awards from being reopened or challenged before domestic courts, and which is supported by a set of mutual obligations designed to ensure effective recognition and enforcement. So the point we've just been touching on in a slightly different context. The Supreme Court in Mikula repeatedly had regard to that convention scheme, as I showed you yesterday, just to emphasise one point from that at paragraph 106 of MICOLA, which is on page 549 of the authorities bundle. It's that sentence which says, the failure of any contracting state to enforce an award in accordance with Article 54 would undermine the convention scheme on which investors and contracting states all rely. That is something we emphasise. That's the first point. Second point is that our interpretation is also supported by Article 69 of the ICSID Convention, which can be found at bundle page 2849, main authorities bundle, 2849. That says, Article 69, each contracting state shall take such legislative or other measures as may be necessary for making the provisions of this convention effective in its territories. Now, time permitting, we will get to, in the Travaux, I'll be able to show you that this provision actually started as a sub-paragraph to what became Article 54. But for your notes, just in case we run short of time, it is page 3265 of the authorities bundle and page 357 of the supplemental bundle. In the first reference, it is a reference to Article 57.4, as it was in that time. And in the supplementary bundle at 357, it is footnote 13 that I would direct my lords and my lady to. So, but the point is, Article 69 is concerned with, amongst other things, effective recognition and enforcement. That's the second contextual factor. The third point of context derives from Article 54.3 and 55, and that is that the obvious point is that those provisions preserve immunity from execution. In contrast, there is no preservation of immunity from adjudicative jurisdiction in Article 54 or elsewhere. And that is unsurprising in my submission because the obligations in Article 54 to recognise and enforce are inconsistent with the maintenance of adjudicative immunity. So we say those three contextual points support our reading of Article 54 as involving a waiver of adjudicative immunity, and there is not really much coming the other way. Object and purpose, then, the last part of the Article 31.1 exercise. It is, importantly, the object and purpose of the Convention, not of a specific provision of the Convention, contrary to what my learned friends for Spain suggest in their written case and submissions yesterday. The dispute on the written cases between the parties is a narrow one as to whether mitigating sovereign risk, in particular through ensuring effective recognition and enforcement, is part and parcel of the object and purpose of the ICSID Convention or not. In my submission, it plainly is, and that should be uncontroversial given it comes clearly from the preamble to the Convention and confirmed in the Travaux. In our written case at paragraphs 52 and 53 and footnotes 99 and 100, we have taken up the task of matching the preambular paragraphs of the ICSID Convention with some of the corresponding parts from the Travaux that confirm what those preambular paragraphs mean. There are many more.
Sorry, it's paragraph which of your case?
It's paragraphs 52 and 53 of our written case and footnotes 99 and 100. I was proposing, I'm happy to take my lords to that, but I was proposing in the interest of time, and since it wasn't addressed by my learned friends, to leave you with the references.
Can you just give me a page number in your core
yes.
bundle?
It is core volume page 132.
Thank you.
So the border Core 132.
Yeah.
That is, we say that shows you the right analysis. The Court of Appeal, in this case, correctly identified the object and purpose of the ICSID Convention in the same way. You find that at the judgment of the Court of Appeal, paragraph 80, which is in our key documents bundle at page 143. And the High Court of Australia came to the same conclusion as to the object and purpose of the ICSID Convention in the same way. That you find at paragraph 34 of the High Court of Australia's judgment, which is at Authorities Bundle, page 1684. And we say it's consistent with the objective of mitigating sovereign risk that Article 54.1 constitutes a waiver or a submission, because it supports the effective scheme for recognition and enforcement of ICSID awards against contracting states. Conversely, Zimbabwe's interpretation is inimical to that objective because it allows contracting states to block, or at least substantially complicate and delay enforcement of ICSID awards by asserting immunity from adjudicative jurisdiction, thereby undermining the scheme of effective recognition and enforcement that the Convention was intended to create. So, at the end of our Article 31.1 process, the meaning of the text of Article 54, read in context and in light of the object and purpose of the Convention, is in my submission clear that each state has consented to each other contracting state exercising jurisdiction to recognise and enforce ICSID awards, including those to which it is a party. That is a waiver of adjudicative immunity, and that is a submission for the purposes of Section 2 of the State Immunity Act. We say that in this case, Zimbabwe's proposed interpretation of Article 54 would leave the intended operation of the Convention scheme substantially undermined, would mean that a regime for effective enforcement that is supposed to work in both directions only works really in one direction. Lord, I also
at least in member states which have something like our state immunity regime, yeah.
Yes.
I mean, there are one or two like France, which, so far as the adjudicative jurisdiction is concerned, don't.
Correct. Yeah. Now, my Lord, my learned friend relied yesterday, my learned friend Mr. Moulin relied yesterday on Pinochet in this regard for 2 points. The first point was that the agreement to exercise jurisdiction in the Torture Convention, he said, did not amount to a waiver of immunity. He took that as a point from Pinochet. We say that's wrong. In fact, only one judge in the House of Lords so found, Lord Gough. The remaining 6 judges either found that there was a waiver, that was Lord Saville, or found that there was no immunity in the first place, so nothing to waive. We've set out the detail of our analysis in that regard in our written case, which is at the Border Core, pages 139 to 147, paragraphs 67 to 86. And I don't propose to say more about that at this stage. The second point that my learned friend relies on Pinochet for is that they say its authority that an agreement to exercise jurisdiction could only ever be a waiver if the agreement would otherwise be completely deprived of all effect. That is also wrong. In Pinochet, the court was not purporting to set any general test for waiver of immunity. It is plainly sufficient that, as here, the effect of maintaining immunity would be very substantially to undermine the ICSID Convention scheme. Now, just last thing that I would say on Pinochet, so that you have our position clearly. We set out what we say the ratio is in those passages of our written case that I've referred you to a moment ago. That is that the ratio is that there was no immunity at customary international law. But we accept that was quite a conservative reading, and that there is a more favourable reading for us arising from the analysis of the court in Jones and the Court of Appeal in Lama, which is that the Convention Against Torture involves a waiver of immunity. So, if anything, we submit that the Pinochet decision, properly interpreted, supports our position, but in light of the uncertainties surrounding that decision, we do not positively rely on Pinochet or need to. But on any view, it cannot be read as supporting Zimbabwe and Spain's case. The next point I'd like to address you on shortly is the arrest warrant case. Unfortunately, you've not had the benefit of written submissions on this because it only came in the supplemental bundle a couple of weeks ago, despite the level of reliance that's now placed on it. I'm afraid I don't have the time to address you on it in great detail, but I would like to make some important points about it. 3 points, really. The focus of my learned friends is on paragraph 59 and what the International Court is saying there about you can't assume from a grant of jurisdiction an absence of immunity. My first point is...
Do you have a page for that?
That
look at it.
Is... It's supplemental bundle, page 120.
Thank you.
My Lord. Now, my Lords, if you began on page 119 and read paragraphs 56 to 61 of the arrest warrant case carefully, you will see that paragraph 59 is not actually about waivers of immunity. It is about whether there is an exception to the customary immunity for war crimes and crimes against humanity. That is the question the court was being faced with. Specifically, what paragraph 59 and what the court is saying is that by signing up to treaties, that does not create a customary exception or change custom. So it's really making a point about the relationship between treaty and the content of custom in international law.
So whether there's an exception in customary international law is the question that's being addressed.
My second point is that paragraph 59 has to be read in the light of paragraph 61 that follows it, which is over the page at 121, where reference is made to a waiver of immunity. The court, in my submission, cannot have been intending to say in paragraph 59 that every single treaty that requires the extension of criminal jurisdiction cannot contain a waiver. That would require each treaty to be interpreted separately according to its own terms, in its own context, and in light of its object and purpose as a whole. My third point is that paragraph 59 appears in the context of an explicit caveat from the International Court that it is only dealing with criminal jurisdiction in respect of persons entitled to immunity ratione personae, such as the incumbent Minister of Foreign Affairs. That is clear from paragraph 51 of the judgment, which is on page 116 of the bundle, where the court makes specific reference to the special status of certain holders of high-ranking office, such as the Minister for Foreign Affairs, who enjoy immunities from jurisdiction in other states, both civil and criminal. And they say, for the purposes of the present case, it is only immunity from criminal jurisdiction and the inviolability of an incumbent Minister for Foreign Affairs that fall for the court to consider. So we disagree with my learned friend Mr. Bastin's submission to you yesterday that paragraph 59 is a statement of general principle. It is, in my submission, very specific. The International Court at paragraph 51 has distinguished even other types of immunity that apply to individuals as well as immunities in the civil context. And the present case, the case before you today, is even further away from that in terms of analogy, as we are talking about state immunity, not individual official immunity, and we are talking about civil matters, not criminal matters. Indeed, as my lords, my lady well know, criminal matters are explicitly carved out of the State Immunity Act in section 16(4). The courts of this jurisdiction have before acknowledged the distinctions between individual and state and civil and criminal immunities and the inappropriateness of stretching analogies too far. I don't have time to take you through them, but I'll give you the references to two. Reyes, which is at the Supplemental Authorities Bundle, paragraphs 27 and 28. Pages 16 to 17, my lord. And in Jones, which is at the Supplemental Bundle at page 53, per Lord Bingham, at paragraph 32.
And those references are to?
They are to the dangers and the inappropriateness of stretching analogies and the distinctions between individual immunities and state immunities and civil and criminal immunities.
Thank you.
So in fact, arrest warrant actually runs harmoniously with Pinochet, what was said in Pinochet number 3, because it was accepted, I think, on all sides that there, insofar as there was a waiver of immunity, it didn't touch immunity ratio personae.
I think that's right, yes.
And arrest warrant is essentially saying, in a different context, something very similar to that.
Yes, my lord. So, to conclude, we say arrest warrant read in its proper context cannot be understood as identifying any sort of new rule of treaty interpretation that would preclude clauses requiring the extension of jurisdiction over states from constituting express waivers of state adjudicative immunity. And that is how the two states parties to this appeal seek to use that case effectively as a rule that would bar the outcome. Having therefore concluded Article 31.1 and explained our position on Pinochet and arrest warrant, I now move briefly to the third part of my submission, supplementary means, Article 32 of the Vienna Convention. Turning to the rule reflected in Article 32, in my submission, as I said yesterday, the meaning derived from the Article 31.1 exercise is clear, and so recourse to the supplementary material, in particular the travaux to the ICSID Convention, is not necessary. However, if the court is minded to look at it, it may only do so to confirm the meaning that it has arrived at from the cardinal rule Article 31.1 interpretation. And the travaux in my submission do confirm that consent to Article 54 constitutes a waiver of adjudicative immunity. Even if, however, you're against me on that, and you consider Article 54.1 to be ambiguous or obscure, or to lead to a manifestly unreasonable or absurd result, then, and only then, you can look at the travaux to determine the meaning. But very importantly, you can only use the travaux to do so if there is a definite legislative intention discernible, or a bullseye, in the words of this court in JTI Polska. That is at paragraph 32 of JTI Polska, which is at page 471 of the authorities bundle.
Is it paragraph 32? Polska.
Paragraph 32.
Yeah, thank you.
Page 471.
Only if a bullseye or...
if you can identify a definite legislative intention or a bullseye.
Thank you.
It has to be super clear, recognising the difficulties that travaux, being long history of negotiation, reflect.
That's sort of equivalent to our statutory construction only if the ministerial statement directly gets to grips with the point in question.
I see the analogy. The only hesitation is because of the references to English contract law that have been made in the written cases. I don't want anybody to think that we can analyse this through English contract law, but it's perhaps for some of the same policy reasons.
Yeah. Bullseye was Lord Steyn originally, wasn't it? It's just a sort of general conveying the nature of the requirement.
Correct, yes. So, on the travaux, I mentioned yesterday 4 real disputes on the travaux. First dispute, whether the primary purpose of Article 54.1 being to facilitate recognition and enforcement against investors means that it cannot contain a waiver, as my learned friends suggest. The answer to that question is no. We accept that one of the main purposes of Article 54 at the time it was drafted was to enable states to enforce against investors. And that was due to the assumption, which seems rather quaint today, that states would comply with awards. I say quaint as Spain stands before you today with 20-something awards amounting to in excess of $2 billion unpaid, and Zimbabwe stands before you more than 10 years after being ordered to pay their clients over $120 million, and then undertaking to the ICSID ad hoc committee that it would pay if it lost the annulment and still doesn't pay. Yet at the same time, it was always accepted that Article 54 would not operate solely in one direction, and that investors would have the same rights as states under Article 54 as regards the entitlement to recognition and enforcement of awards where states lost an arbitration. Let me show you just 2 examples to make that point good. The first is at page 3199 of the main authorities bundle. 3199. This is the discussion of the first preliminary draft of the convention by the executive directors of the World Bank in September 1963. And if we can pick it up at paragraph 8, Mr. Ullerer requested various clarifications. If you go down to 3 lines up from the bottom of that paragraph 8, as to enforcement of awards, Mr. Ullerer asked whether it was certain that all awards under the Convention would be enforceable in all contracting states, particularly awards made against a government. If we then go over the page to 3200, Mr. Brockers responds to that, paragraph 12 on page 3200. And he says the question of enforcement hasn't been covered specifically in the working paper, We pointed out in earlier discussions that it would be desirable to have a very clear provision on that matter, and such a provision was now included as Section 15 of Article 4, which require that each contracting state recognise an award of a tribunal as binding and enforce it within its territories as if that award were a final judgment of the courts of that state. That was quite a step forward in the recognition of international arbitral awards when compared with the general law in most countries. As to whether forced execution following upon an award could be obtained against a government, that would depend on the force of a final judgment in the country in which enforcement was sought. In general, it would not be possible to enforce a judgment against the state in the sense of seizing its property and selling it in forced execution. But this did not seem to present a major problem. Hardly any cases in which there's been difficulty in obtaining compliance with an award once its binding character was clearly established. So that's the first passage. The second extract that I wanted to show you was one in which Mr. Bastin took you to yesterday. I'll ask you to turn it up again quickly. It's at 3215. 3215, my lords and lady. This is from the Santiago meetings in February 1964. You can see there, the fourth line down, the chairman is saying the principal purpose of Section 15, brackets, although this was not its only effect, close brackets, was to give states which had been successful plaintiffs a mean to enforce awards against investors who did not have assets within the host state's territories. States would be directly bound by the Convention to comply with the award rendered against them, which would not be void of investors. In the unlikely event that a losing state failed to comply with an award, it would be in clear violation of the Convention itself, and the state whose national had failed to obtain satisfaction could take up his case. So it was contemplated from the outset that what became Article 54 might be used against states, even if that was not expected to be very common, because states were going to be assumed to comply. It doesn't support the position of Zimbabwe and Spain that there cannot be a treaty waiver. Just picking up the point that Zimbabwe and Spain made, they also suggest that there'd be no need for revival of diplomatic protection in Articles 27 and 64 of the Convention if there were a waiver. That is not correct. The revival of diplomatic protection was to account for non-compliance, i.e. non-payment. Recognition and enforcement, as we know only too well, is no guarantee of payment, given domestic laws on immunity from execution still apply and may prevent an investor from obtaining satisfaction. So that's the first dispute. The second dispute on the Travaux concerns the repeated statements, in particular by Mr. Mulan on behalf of Zimbabwe, that the Travaux reveal that states' domestic laws on adjudicative and execution immunity were to be left untouched. The short answer to this is that the comments were only made in the Travaux in respect of immunity from execution. The position was different as regards immunity from adjudication in respect of recognition and enforcement proceedings. It was always understood that there would be recognition and enforcement of such awards, which is inconsistent with the maintenance of immunity. Time.
There was at some point, wasn't there, an issue though about scope of it, because it was cut back in the final version to pecuniary obligations. So there was some dispute about whether you could get injunctions and so forth against states.
Yes, and it is only pecuniary obligations that are enforceable.
Does that shed any light on this point or not really? It's in the. It was presumably in the context of whether the award, that there'd be any way, any kind of defence that you could raise, or in any circumstances in which you could resist it being treated as binding.
I don't have the reference to my fingertips, but my recollection is the issue was to do with the types of relief that ICSID tribunals could award that the states were prepared to accept being enforced against them. ICSID tribunals make various provisions ordering states to do things, but it's only the pecuniary ones that are enforceable under this mechanism. But in my submission, that doesn't affect the analysis on this. Lord, just take you to a few references in the interest of time. The initial list of references that Mr. Moulin gave you yesterday, gave you a list 3206, 3211, 3221, 3244, 3245. They all refer to immunity from execution, not recognition and enforcement. The text is largely similar in each of them, so I will turn up the last one, just for the sake of argument, at 3245. Starts at 3244. It's this paragraph at the bottom of 3244 that begins, fourthly, awards of arbitral tribunals rendered in pursuant to the Convention will be recognised by and enforceable in all contracting states as if they were final judgments of the national courts, regardless of whether the state in which enforcement was sought was or was not a party to the disputing question. In that connection, you wish to make clear that whereas in most countries the law of state immunity from execution would prevent enforcement as opposed to execution against a private party, the Convention would leave that law unaffected. All the Convention would do would be to place an arbitral award rendered pursuant to it on the same footing as a final judgment of the national courts. If such a judgment could be enforced under the domestic law in question, so could the award. If it could not, neither could the award. So that, my submission, doesn't take matters very much further forward. Second point is, yesterday great focus was placed on the Santiago meeting, and you were taken to pages 3,214 to 3,217, involving exchanges by the Jamaican and US delegates. Time will not allow us to read those pages together, but if you read that whole section, my lady, my lords, from 3213 to 3218, it is abundantly clear, we say, that read in context, the discussion is about execution immunity, not adjudicative immunity. It is also evident in the fact that the proposal made by the chairman during that discussion, and what then becomes Article 55, is about and limited to execution immunity. And the model for that was the Treaty of Rome, which is cited in that section, which deals with forced execution. You see that at 3214. I'll also just give you, we can perhaps, as the final thing, turn up the article by the chairman, Mr. Brockes, in 1987, publishing his commentary to the ICSID Convention. Supplemental bundle at 317. So there you have, at 317, this is Mr. Brockes' article, and he is describing here, at 317, the Santiago meetings on which so much emphasis was placed, and he makes clear in the second and third paragraphs, summarising those exchanges, that they are about immunity from execution. You see, for example, it says halfway down, a third of the way down the page on the right, Mr. Rattray, Jamaica, thought that the Convention should make it clear that the doctrine of sovereign immunity from execution was not affected. I agreed and suggested wording along the lines of what is now Article 55. He also thought it would be worth considering some notion of international public policy as an exception. And then, with respect to sovereign immunity from execution, Mr. Lowenfeld of the United States would draw a distinction between enforcement in the state which was party to the dispute and state of another. So we looked at that yesterday. So again, confirms that Mr. Lowenfeld's use of the term enforcement when he's speaking about it is actually talking about execution. It's clear from the context. Lord, the fourth and final point on Travaux, which, if I can just make that and then I will sit down, not having been able to address you, unfortunately, on the judgment of the High Court of Australia or the other courts or the New York Convention point. Fourth and final dispute about the Travaux. Zimbabwe and Spain place quite a lot of weight on what they say are silences in the Travaux on waiver of adjudicative immunity. They say an interpreter should not accept states to have given up an important right without any explicit mention of that in the Travaux. I have 3 points on that.
That's picking up on Lord Gough in Pinochet, isn't it? Where he talks about the silencings being remarkable if the submission he was rejecting was correct.
So I'll cover that in my 3 points. The first point is where a Travaux doesn't say anything explicitly on an interpretive point, the theme of the discussion can support the interpretation arrived at, including where that interpretation is that there's no immunity. That is similar to what occurred in Basfar and Wong. Which in the interest of time, I know it's familiar to 2 members of the court at least. If I could invite you to read paragraphs 59 and 60, particularly of that judgment. I will give you the page 108 of the bundle is the starting point. Page 108 of the authorities bundle is the starting point of
main authorities.
Main authority bundle.
The main.
Main or supplementary.
Main bundle. Apologies.
Thank you.
In my submission, when you read that case was a case where there was silence, there was an absence. Mention is then made at paragraph 61 about the ILC commentaries on what became the relevant provision. But what is said is, despite not addressing the point explicitly, the general theme of the discussions recorded in the Travaux showed that matter fell within one of the agreed exceptions and that the states had agreed that there would be no immunity in such cases. We say that's instructive because here the theme of the discussions in the Travaux is very clearly that there would be recognition of enforcement of ICSID awards, including against states, and that represented a step forward for states, but at the same time, immunity from execution would be preserved and left intact. And that was made clear for the avoidance of doubt in Articles 54.3 and 55. To borrow the language of my Lords, Lord Briggs and Lord Leggett in Basfar, we say it would be wholly inconsistent for there to be consent to states being obliged to recognise and enforce awards, including against states, but at the same time to provide for the maintenance of adjudicative immunity. We therefore do not consider that there's any real silence in the Travaux on which Spain and Zimbabwe can seek to rely. I'm grateful for the slight indulgence.
A slightly late sitting. Thank you, Mr. Harris. We're grateful.
On time. Unless there are any further questions, those are the questions.
We're grateful. Thank you very much. Mr. Green.
If I may, can I just pick up the point while we're still on the... I don't know if the court's still got the Brockes extract. In the supplementary... I've got it in the supplementary bundle at 317. Can I just pick up the point on the bullseye, Lord Staines's bullseye, and the danger of island hopping through the Travaux, because they are vividly illustrated by the page to which my learned friend Mr. Harris has just taken the court. The reason you have the bullseye is because the Travaux stretch over a period from 1964 all the way through to 1965 and reflect a moving target as to where agreement would finally be reached. And therefore, island hopping can be dangerous. And the danger in the present case is that the part of the bundle that we were looking at before had not all of the pages in the original. This is the full version of Brockes in the supplemental. And what I'd invite the court to note is that just above the passage my learned friend referred the court to on page 317, if one comes into the second paragraph, halfway down the second paragraph, the words was somewhat academic. Does the court have that? Mm-hmm. Okay, the next sentence. I also said, this is Mr. Brockes, I also said that equating an award with a final judgment would leave unaffected the law of sovereign immunity from execution in the country where an award against a state was sought to be enforced. Unequivocal. But note the footnote. Footnote 73. If you go down to the bottom of the page, footnote 73 refers to page 304 in the Travaux. And we find page 304 in the Joint Authorities bundle at page, let's just on something slightly funny there. The Joint Authorities bundle at page 3211. And the court will remember that page 3211 was the page to which my learned friend took the court when he was making the submission that sovereign state immunity was not going to be waived. And the court, just for the court's note, that is in the transcript, day 1, page 39, little page 151, line 6. And it needs to be read in context with the submission on page 150 that runs into it, which is the bit where the court will remember my learned friend gave page references, a string cite of page references where one would find that the Travaux showed immunity was not being waived. And 3211 is page 304. You'll notice, if the court just scrolls up a tiny bit.
On 3211 or 3...
Sorry, on 3211.
Yes.
If you scroll up, page 3210 is page 301 of the Travaux. So yes. 302 and 303 are not there.
Oh, yes.
Right. So it's really important for the court. I mean, this is why the bullseye point and not island hopping through Travaux is important, because it's possible to get the wrong impression. But the substance of what's being discussed on page 304, which is the 3211 reference that the court will find my learned friend Mr. Moulin relied on. That is page 304 of the Travaux, as you see at the bottom of 3211. And when you go back, having identified that that is page 304, you go back to 2917 in the Joint Authorities bundle.
Sorry, back to 2917?
2917, which is the page my learned friend was taking the court to.
We just looked at that in the supplemental bundle, is it?
Sorry, I apologise. I've got the two.
It looks the same to me.
Yeah, it's the same. It's the same page. The point is the same. Is I just wanted to do the whole circuit round. You come back to footnote 73, halfway down the paragraph, which I showed the court at the beginning of this exercise, and footnote 73 is page 304. So we can tell that Mr. Brockes, his account of what he said at that meeting is the sentence just before what my learned friend Mr. Harris said, which we find there by the top hole punch, or wherever that would be electronically in the second paragraph, halfway down, after somewhat academic. I also said that equating an award with a final judgment would leave unaffected the law of sovereign immunity from execution.
Well, that's what it says in the Travaux anyway.
Exactly. So there is no warrant for saying that sovereign immunity in relation to the adjudicative jurisdiction was not going to be waived, or there wasn't going to be submission. So it's a relatively small point. All
you've shown us is that Mr. Brock has accurately summarised what he'd said in the meeting.
Well, there we go. Maybe not establishing very much. There's one further point my Lord Legate asked about what enforceable meant. And there's a short point on that, which is that the word enforceable and enforced were debated quite heavily. And Mr. Brockes, at 2924 in the Joint Authorities Bundle, I mean, there are other references, but time doesn't permit. But the short point lands on page 2924, top of the page, first new paragraph. A comment is in order on the use of the term enforce in Article 54.1, which standing alone might be considered as including execution. Paragraph 3 deals separately with execution, make sure it's not the intention, but a slight awkwardness remains. When that paragraph is added, the first paragraph should have been reworded and might, for example, have read, and then he substitutes the word enforceable.
Well, that tells you what it doesn't mean.
But, my Lord, there's, when you read it as a whole, which I'll come to in my proper submissions, there's no real ambiguity about what Article 54.
Can you just help me, give me some homely example of an enforceable, a means of enforcement of a pecuniary obligation other than execution?
Well, my Lord, there's recognising it as enforceable, so that Travaux and Schroyer, for example, make clear that it can operate as res judicata in a defence.
Yeah.
And the pecuniary obligations are recognised as enforceable, subject to the question of whether the Article 55 point, subject to the individual states' local laws as to immunity from execution for sovereign states. So,
I see.
I'll come to this point.
So enforceable might be by way of execution, but in a little corner of the execution world not covered by sovereign immunity.
Correct.
Right.
So
which would, and there's a capacity for that to work under.
Yes, and my Lord, that goes to a much bigger point that I was going to make anyway. I'll make it now, I might as well. There is actually, if you'll forgive me, I will actually lay the ground for it, because otherwise I don't think it's going to make sense as clearly. So the court will appreciate that our case is that Spain's not entitled to state immunity because under Section 2.1 of the 1966 Act, respondents are entitled to have their authentic ICSID award in the terms of Section 1.4, registered in the High Court on proof of the prescribed matters and the other provisions of the Act. And that's what the Act says. And the effect of registration is provided by Section 2.1, and those provisions implement the obligations under Article 69 in the Convention, as you've already heard. I won't repeat, but I adopt the submissions from learned friend Mr. Harris. And neither the Convention nor the 66 Act affords Spain any avenue to challenge the award. You don't get the wording you get in the New York Convention referring to other provisions, and you don't have the equivalent of Section 103, and because there's no seat, you haven't got Section 67 either. And that leaves no room for any de novo or other reconsideration of the award, including aspects as to jurisdiction, and I'll make that point good. Not least because de novo reconsideration of jurisdiction would defeat the self-contained nature of the scheme, would defeat the object of finality and effectiveness, which is one of the chapter headings in Mr. Brox's book, would conflict with Spain's own emphasis on state immunity as a preliminary bar, which I think was the point my Lord Legate was making earlier. Once you've got to final judgment, you've skipped over, you're miles beyond any preliminary bar to entertaining the proceedings. So it can only mean that, and there's no room for any other reading. And that's true as a matter of domestic legislation as well as on the convention. So that's put beyond any argument. What the court is bound to do is the task set out in the 66 Act, which makes it clear beyond argument, we say, in any event. But furthermore, de novo review would also lead to a fracturing the scheme of enforcement by rendering authentic awards enforceable or not enforceable in different contracting states, depending on the view taken of the arbitration agreement on a de novo assessment by different states. And that's absolutely not what the Convention was intended to do. It was intended to be a uniform recognition by all contracting states through the process of registration, and thereafter leaving the question of immunity from execution to the domestic laws of those states. And my lords, can I say this? That what the Convention was aimed to do has not been achieved in one respect, in the sense that the Convention aimed to identify an outcome, namely treating as a final judgment, of the domestic court, because they toyed with a foreign judgment and rejected it expressly. So they chose an outcome that jumped over all of the problems that might differ in how France treats state immunity. So the questions that the court's been hearing from a learned friend about the High Court of Australia having different rules, the US having different rules, do not arise and were not intended to rise at all. The whole point was, first of all, to go right over the top of all those issues which would differ, and those differences did not need to be harmonised, which we see in Schreier and Brockes. Those differences would not need to be harmonised at all, because you jump right over them to the end point of a final judgment of a domestic court, and then you say, thank you very much, we've got that, that's clear for everybody, then up to you on your execution depending on your local law. And that was the balance that was struck to get consensus. And actually it's plain that the capital exporting and the capital importing countries both had good reasons to agree to that. So that was what the Convention was seeking to do. And in that sense, and insofar as I need to make the point, which I don't accept I do, but in that sense, it would qualify as what was referred to as a special scheme in AES, which is in the bundle, paragraph 35 of the AES authority, at AB, the Joint Authorities Bundle, tab 12, 92 to 93. I may come back to that if I have time, because I'm very aware that my main task here, my lords, is, lady, to be a warm-up act for Professor Webb. So insofar as there's any domestic support needed for the possibility of having a special scheme where arbitrability is decided by the arbiters, the competence is vested in the tribunal, and that's a special scheme. AES recognises there can be such a scheme, but that is not necessary to our argument, it's just helpful. Now, can I now turn to this issue of express? And I hope there might be a sigh of relief from the court, possibly, but we say that's not really the question. Express is not the question. The question for the court is actually a much more straightforward one, and it is looking at the convention in a conventional manner in accordance with the Vienna Convention. Has consent been given? And this springs from a proper analysis of the principles of sovereign immunity and par in parem. And that provides a very solid foundation for the submission that what is quintessentially an issue is the question of consent. What has been consented to? And can I just pause to make one sub-point before I proceed with this analysis? The sub-point is this. True it is, where there is a submission by contractual agreement, that the proper law of that contract may have a role to play to work out what the parties as a matter of domestic law have agreed. But you then have to ask the question as a matter of using international law principles in this jurisdiction to say, given they've agreed that, does that amount to consent applying normal international law principles of submission to the jurisdiction? But in a convention case such as this case, totally irrelevant. All you're looking at is, as a matter of international law, we get this from Allcom, Lord Diplock, and it goes all the way through Benkelbush, and I'll show the court. All you're looking at is the question of, as a matter of international law, have these contracting states made an agreement and given their consent to something which necessarily involves there being no state immunity?
But the second half of that is an English law question, or a UK law question. The first half is an international law question.
Well, my lord, I'm not sure that's necessarily right, because
well,
I see what
they've done
your lordship's
within
absolutely
Section
right.
2.
Yes, your lordship's
That's a
absolutely
question of construction of a UK statute.
Yes, but the primary question, because Section 2, in Allcom, Lord Diplock says that we look at the State Immunity Act through the prism of international principles of international law. We respectfully say the question of submission in Section 2 is conclusively answered if contracting states have agreed between themselves to do acts which can only be done without state immunity. So, and I completely agree with your lordship that that final sliver is a question of domestic law.
Where you disagree is it's just a sliver.
Well, yeah, it's a component, I agree. It's a component. But picking up the observations of my Lord Sales yesterday, and indeed today about reading it long and so forth, and that we respectfully say that is absolutely the right approach, without any qualification. Because the question is, what have the states agreed to do? And that is why object and purpose are important to reach a view on what the states have in fact agreed to do. And there is powerful support for the centrality of the idea of consent of sovereign states, not only to be found, as my learned friend referred to, but if I can take the court to Benkelbush, if we go one second, it's page 118 in the authorities bundle. It's the judgment of Lord Sumption. And one second. The relevant paragraphs are paragraphs 17, particularly at the letter D on page 800. The rule where it applies is that a state may not be impleaded in a domestic court against its will. In italics, Lord Sumption's emphasis, not mine. State immunity may be waived. Waiver does not dispense with the rule. It's inherent in the rule. It's a voluntary submission to the forum court's jurisdiction which constitutes the consent that has always qualified the rule. So, my lords, that's why I say, not just as a matter of international law, but international law, as understood in the judgment of the Supreme Court in Benkabush, as a matter of English law, consent is the foundational principle on which this issue is to be determined under Section 2. And that dispenses, we say, with a potentially awkward semantic distinction about what we mean by express and so forth. And yes, of course, the court will say, when the parties have agreed this, have they unambiguously agreed something that means that there can be no state immunity? Of course, one's going to be satisfied, it's got to be clear in that sense, but I wholly take my Lord Legate's point that finding what the meaning is, it involves clarity and lack of ambiguity. You've got to make a decision about what it clearly means. So there may be...
You need to introduce confusion when you start talking about clear, because normally the argument, and I think this was the argument in general dynamics, is that sometimes there's a presumption against a particular conclusion.
Yes.
And then you have to find clear and unequivocal to overcome that presumption.
Exactly.
And the argument, I think, in general dynamics was relying on the sort of Gilbert-Ash principle that you haven't given away a right without clear words.
Yeah.
And that was rejected.
Yeah.
So then all you need, if you don't have that clear and unequivocal, then it's just a matter of construing the words on normal principles without any presumption to overcome.
So, my Lord, fundamentally, I completely agree. Can I, as a practical point of courts considering the exercise of jurisdiction over other nation states, as a practical point, out of comity, the court will be careful to ensure that state immunity is not waived by a side wind. And that's the only sense in which we're talking about clarity for these purposes. So, subject to that gloss, my Lord, I completely agree with my Lord Legate's analysis that you look at the meaning and you find what the meaning is. And as the court will appreciate, I'm going to be making a submission that the meaning is very clear, both on the Act and in the Convention itself. So, my Lords, can I mention this, because this goes into the background to the foundation for that submission about par imparem. There was a summary of the law by Mrs. Justice Dias at paragraph 8 in her judgment, which, and this is just by way of assistance to the court, summarises everything, ignoring NML and the observations of Lord Collins, explaining that the position was much more complicated and going through the authorities and so forth. But and that was at in our skeleton and before the Court of Appeal at page 385 of the Spain Call Bundle and in footnote 8. I don't need to take the court to it, but it is right to say that even in the Sultan of Johor, one of the judgments considered the treaty status of the Sultan, having agreed to not enter into any other treaties with any other countries, and that he might lose that status if he breached the treaty. So I'm not going to take the court. I did email, I think my sister's kindly emailed the Sultan of Johor to the court. I won't take the court to it, but all I'm going to say is that the international law plane has, and the ability of sovereign states to change the state immunity by treaty has existed as long as time. And an important point for looking at the consent and the second facet of that, which I'm going to come on to, which is limitation of sovereignty or limitation of state immunity, any aspect of sovereignty, including state immunity, by treaty is a sovereign act, and that is that's the SS Wimbledon case, which the reference to which is at page 1206, and I'll just read it out. I won't take the court.
How do you say Wimbledon has any bearing on this case?
Well, only because, well, I'll take the court to it. 1206 is a short point, my lord, just as a matter of international law. Does the court see the words "this contention"?
Sorry, what page are we on?
Oh, I'm so sorry, 1206.
Thank you.
Which paragraph?
It's a long paragraph.
No,
It's a very long paragraph.
About halfway.
So if you come halfway down on the left-hand margin, my lady's got the court's not convinced, the contention not convinced the court. And if you come down to just after the word peace, on the right-hand margin, where the, this is the key passage.
Sorry, are we in the first complete paragraph?
First complete paragraph.
How many lines down, roughly?
Come up from the bottom by about 8 lines. Right-hand side, 5 lines up is no, 8 lines up is the.
Yes.
So there, the court declines to see in the conclusion of any treaty by which a state undertakes to perform or refrain from performing any particular act an abandonment of its sovereignty. No doubt any convention creating an obligation of this kind places a restriction upon the exercise of sovereign rights of the state in the sense that it requires to be exercised in a certain way. But the right of entering into international engagements is an attribute of state sovereignty. So just pausing there, the only point to take from this, which I hope is completely uncontroversial, but I hope you'll forgive me for making it, is that, and it becomes even more acutely relevant when we look at Article 192 of the Treaty of Rome. An attribute of state sovereignty may include waiving immunity, submitting to the jurisdiction of an international tribunal or an international arbitral tribunal, or indeed waiving other aspects of sovereignty. And I know at least one member of the court may remember my submission of the Gina Miller case, which was that the ability to legislate was parliaments to exercise, parliaments to confer on the European Union, and parliaments to take back. So that was an example of conferral of a sovereign competence of this country in the EU context. So international law recognises that the entering into of a convention may involve a restriction on the exercise of sovereign rights or some other impact on aspects of sovereignty in that way. So there's absolutely nothing controversial at all about what was contemplated in the convention, but the court will remember my learned friend took the court to the reference to Article 192 in the Travaux. And there is a danger in conflating everything on the timeline of what happened into one moment. It's actually instructive to consider what the position as a matter of international law on state immunity was before the convention, what happened when the contracting parties entered into the convention, and then later, for domestic law purposes, 12 years later, after we say the 66 Act had been perfectly effective, because the 66 Act had altered the common law as to state immunity in respect of convention awards, what later happened in the SIA 12 years later. So, just taking it in stages, a learned friend, Mr. Moulin, suggested that there was something that, as Lord Legate was putting to me, some reason why the states would not have agreed to waive state immunity. And in fact, he pointed to Article 192 in the Travaux as confirming that. And the opposite is in fact the case. So the court will have in mind that in 1957 the Treaty of Rome was enacted. The effect of that was reasonably well understood internationally and remarked at the time a remarkable innovation in the limitation of some sovereign rights and the conferral of those rights on the European community as it then was. And my learned friend took the court to page 3214 in the Joint Authorities Bundle on Article 192 and made the observation that Article 192 in those terms was not about states. And if the court goes forward to the page that we referred to in our written case, which is on 3232, and it's internal page 425 of the Travaux, and I pause to say, I entirely adopt my learned friend Mr. Harris's submissions. That reference to the Travaux is unnecessary and not available because there is no ambiguity. But if one were to go to that, as I've already highlighted the dangers of island hopping by reference to Mr. Brockes's account of 3211, it's also important to have this in mind. The chairman said that Article 192 of the Treaty of Rome, does the court have that at about a third of the way down, referred to by the expert from the Federal Republic of Germany, limited enforcement judgments to decisions of the Council against private parties involving financial awards. Second of those two qualifications might be considered for inclusion in section 15. He pointed out that the draft convention had not established any mechanism for enforcement of awards pronounced under the auspices of the Centre. The Treaty of Rome, however, had set up such a mechanism and had also established obligations regarding recognition and enforcement of judgments, which went as far as section 15. Members of the European Economic Community had renounced certain of their sovereign rights and accepted decisions as binding in the same way as was being attempted by the present convention. So the power of the and significance of the renunciation of certain sovereign rights and the acceptance of EU law as binding in domestic courts, that was what Mr. Brockes was equating Article 54 and the scheme of Articles 53 to 55 with when this was being discussed in the Travaux. So it wasn't the point that within EU law it didn't apply to states. The point that he was making was that there was a very significant feature of what the members of the European Economic Community had done, to which he wished to draw everybody's attention, and he expressly said that they'd renounced their sovereign rights and accepted decisions as binding in the same way as was being attempted by the present convention. And with the greatest respect to my learned friend Mr. Moulam, having had that said by Mr. Brockes, there could be absolutely no doubt whatsoever of the reach, the intended reach and effect of Article 54 and the scheme within the convention itself. My lords, may I make submissions in relation to textual points in relation to ICSID. The convention itself, we've got in tab 191 at page 2827. In the second supplemental bundle, just for the court's note, we have got the version of the ICSID Convention that's actually scheduled to the Act. So as enacted by Parliament, and we had that in Mikula, and we had that in that form in the Court of Appeal as well. But it's worth the court being aware that That version is in the second supplemental bundle at page 3.
Does it differ in any relevant respect from the one we've been looking at for the last day and a half?
Well, my lord, no, I'm just...
Oh, good.
And there's no difference. There's no difference. It's only for the court to have in mind that it was scheduled to the Act itself. As regards the Convention, the court's familiar with the key provisions. 2841 is Article 41. The tribunal should be the judge of its own competence. And often not emphasised, but important, is Article 42. Any objection by a party to the dispute that the dispute is not within the jurisdiction of the centre, or for other reasons is not within the competence of the tribunal, shall be considered by the tribunal, which shall determine whether to deal with it as a preliminary question or to join it to the merits of the dispute. So it's specifically allocated that issue of resolving and determining any objection is expressly, not just implicitly, but expressly allocated to the tribunal. And then going forward, the court's familiar with section 5 on page 2843, which is interpretation, revision, and annulment of the award. And Article 52, 1, A and B, but particularly B, it's under B that challenges to jurisdiction are entertained by the ad hoc committee. And the court will know that in the, I could take the court to the award later, but it is under that manifest exceeding of powers that the tribunal, in this case, within the award, considered and rejected the challenge to jurisdiction. And there's a point, an important point there, which goes to the bargain or the consent of the parties, the contracting states, which is there was a deliberate limitation of the scope for challenge. So the scheme of the convention involves two things. Firstly, saying that the objection will be determined by the tribunal and through the preclusion of any other appeal or other challenge, only by the tribunal. And secondly, that it's only in the question of manifest exceeding of powers that will be a ground for setting aside. And that is what all the contracting states agreed to. And a point taken against me is, well, actually, it can't be right that there's no de novo review because you don't get a full opportunity to challenge under Article 52. It's only where it's manifest. The contrary is the case. It was expressly to have finality, which was one of the objects of the convention, and effectiveness, that not only was it to be decided only by the tribunal, but only by the ad hoc committee where the excess of powers was manifest. There were two layers to the limitation in relation to those objections identified that had to be raised under Article 41.2, and it was contemplated they were A, a matter for the tribunal for 41.1, B, had to be raised for the tribunal, which would decide how to deal with them, 41.2, and then 52, narrowing it to only manifest excess of power. That brings me to section 6, and
53 is also part of that scheme, isn't it? I mean, a crucial part of it.
Oh, it's crucial. Exactly, within section 6, exactly. 53.
Oh, sorry, section 6, so you mean over the page, yeah.
Section 6 is 2845, and your Lordship's absolutely right, because Article 53, so all I would say, my learned friend referred quite rightly to 53 to 55 being the scheme, But of course, the scheme embraces, by reference, 50 to 52, and thereby also 41, and necessarily 69, by which there's the obligation to implement in domestic law the scheme that's provided, particularly in those articles. So it brings one to Section 6, recognition and enforcement, and my Lord Legate's absolutely right that Article 53 provides that the award shall be binding on the parties and shall not be subject to any appeal or any other remedy except those provided for in this convention. And that makes clear beyond doubt the submissions I've been making in relation to Articles 50 to 52, which Lord Lloyd-Jones and Lord Sales have already addressed in the Micula judgment, to which my learned friends already referred, the closed scheme nature of the convention. And that's the first sentence. Each party shall abide by and comply with the terms of the award, except to the extent that enforcement shall have been stayed pursuant to the relevant provisions of this convention. And we would respectfully say, insofar as it matters, and it may not, that it's actually a breach of Spain's obligations under Article 53.1 for Spain to contend before this court that the award is invalid for want of jurisdiction. It's a clear breach by Spain of 53.1 to take the position that it is taking in this appeal. And the same equally applies to Zimbabwe.
Well, they might say that Article 53 is about one kind of bindingness, and Article 54.1 is about another kind, because if it was about the same kind, Article 54.1 would be unnecessary.
Well, my Lord, it goes from the general to the particular in that respect, but there's a functional difference as well between 53 and 54, because 54 is dealing with the obligations of the other states.
Yes.
So it doesn't only depend on... So the reason for that, my Lord, is this. As we know, as a matter of international law and domestic law, the court is obliged to consider sovereign immunity of its own motion. So Spain could theoretically remain silent and not make a submission about it. The court would still have to consider the question of sovereign immunity. So that, in a sense, explains why you get this cascade from 53 into 54. And then, obviously, 53.2 includes the decisions made under 50, 51 and 52. So it is also the decision not to annul that's binding on Spain. And then we get to 54. And it's interesting, I mean, it's only an example of the wide language used, but it's each contracting state, not all other contracting states. It doesn't make a functional difference, but it is exemplary of the focus and intent to achieve finality and effectiveness, that there be no loopholes left in these provisions, that it says each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that awards within its territories of a final judgment of the court of state. It's a small point, but it goes to reading along, and you look at what everyone's agreed to. It is a small semantic point, perhaps of no great weight, but if it has any, it's in our favour. Then 54.2 that the court's already considered, a party seeking recognition or enforcement in the territory of a contracting state shall furnish to a competent court or other authority which such state will have designated for this purpose, a copy of the award certified by the Secretary-General, each contracting state will notify the Secretary-General of the designation. Most states where these awards are enforced, I think over 90, mid-90s, have designated those authorities. It's right that there are a number of states that haven't yet, but this country certainly has. And the application is made to the High Court, and within the convention, what did the contracting states agree to? They agreed that all you had to do to seek recognition or enforcement in the territories of a contracting state was to furnish the competent court with the copy of the award certified by the Secretary-General. So that's absolutely express within the convention. It is not a gold plating by the United Kingdom in the 1966 Act at all. All countries agreed to that. And that is why there is no room for any de novo review of jurisdiction in these circumstances. So we say all roads lead to Rome in that respect.
Or away from it, as the case may be.
Well, that's days 3 and 4, my lord. Exactly. But the point is, there's only one way of reading these provisions individually and together, and it's our way, as adopted by the respondents to this appeal, and there is no room for any ambiguity given all the machinery of those provisions read together. There is no room for any ambiguity, such as to bring in the availability of the travaux to clarify such ambiguity as they would contend that the court's got the submissions of learned friend Mr. Harris and asked that when you do look at them, it's abundantly clear from what Mr. Brockes says, and indeed from what Professor Schroyer says in his commentary, to which I may give the court some references after Professor Webb's finished her Pinochet piece, that even the travaux clearly support the position that's clear on the face of the convention provisions themselves. And so it's then the only last one, which we've already mentioned, is Article 69 on page 2849. Each contracting state shall take such legislative or other measures as may be necessary for making the provisions of this convention effective in its territories. So that is the 1966 Act. And this is where one of the features of the temporal analysis becomes important, because it's common ground that although there may have been some confusion about the law of state immunity, see Benkar, Bush and NML, particularly Lord Collins, the arbitration exception, Duff Developments, was not recognised in 1966. So the United Kingdom was not anticipating that this would fit into a scheme of drafting that came 12 years later, in relation to an exception which, by contrast to that reflected in Section 2.2, was not recognised in 1966 at all in the United Kingdom, rightly or wrongly. So there is an immediate question as to, just in terms of a waypoint in the analysis, to look at the 1966 Act as changing the common law position, specifically in relation to these ICSID awards, on presentation of an authenticated copy to be registered as a final judgment of the High Court. And so when you see it in 1966, not through the prism of the 1978 State Immunity Act, you can see even more clearly that is a complete self-contained code for the registration of authentic awards as final judgments, without addressing with any particularity at all in what way it was that the state had submitted to the jurisdiction, or the English courts could properly take jurisdiction over the state. And it's a very vivid example, temporally within the United Kingdom, of the wider point I made at the beginning of my submissions about needing to avoid the differences in views about what was immune and what was not, so restrictive, absolute, and so forth, and indeed completely different approaches in the civil law countries to where you draw the line between enforcement and execution and so forth, by coming up with one single simple concept, like a mortar fire from one side all the way over the fighting battle lines and disputes that there might be, to land in the place where everyone would agree it would take effect. And that place was specified in the Convention and in the 66 Act as a final judgment of the domestic court.
I think it said against you, Mr. Green, that in 1966, as the law was then understood, it wasn't possible to waive immunity, save in the face of the court.
Well, my lord, first of all, it's not correct, but...
Well, that's now been exposed, but that was the understanding at the time.
Yes, but that's precisely why the Convention was necessary and the Act was necessary. So from Mr. Brockes's point of view, and the architects and those participating in agreeing the Convention, that was not an uncommon... There were all sorts of different regimes of state immunity in all the countries. And that is precisely why the, slightly inspired by what had been done with Article 192 with the European Community at the time, the European Community also had member states with different laws, and the European Community had adopted this idea that you jump right over the top and land simply, and if I may say so, elegantly, with a final judgment of the domestic court. And that was seen by Mr. Brockes in the passage I've just shown you as a model for how one avoids the very point my Lord Lloyd Jones puts to me, which was, whatever the law in the state, you couldn't, you could sometimes, you couldn't other times. No one cared. All the contracting states agreed that between themselves, par in parem, with consent, as an agreement, as the Convention wording itself makes clear, that this was what was going to happen, which is why it is a freestanding bargain between states, represents their consent to the exercise of unequivocally represents their consent, each to the other, of the exercise of adjudicative jurisdiction in this process of registration of an award, whilst preserving in Article 55 the immunity from execution. And I'll end on one final point at this juncture, if I may. One goes back to Article 55 at 2845 in the bundle. It's obviously the case that for an avoidance of doubt provision, we'll shed light on the other provisions there. But the first words of Article 55, we say, are also telling. Nothing in Article 54 shall be construed. So it's specifically pointing to Article 54 to highlight that what was being agreed should, within Article 54, would nonetheless not affect anything in relation to immunity from execution. And that's what comes through the travaux, loud and clear, and is plain on the face of those provisions themselves. My lords, my ladies, Professor Webb's going to pick up Pinochet from which we say there was even more support available to our case than was identified in the Court of Appeal. And she's going to do that straight after lunch, and then I will continue.
Thank you very much. We'll adjourn now until 2 o'clock. Thank you very much.